Welcome to Transnational Competition Law course. And dear learner and viewers, I am going to deliver my seventh lecture on the course. And today's lecture is devoted to extraterritorial application of competition law in European Community. Welcome, dear viewers and learner, to the Transnational Competition Law course, and I am going to deliver seventh lectures of this course, which is entitled as Extraterritorial Application of Competition Law in European Community. Dear viewer and learner, welcome to Transnational Competition Law course, and today I am going to deliver my seventh lecture on the course, and the title of my lecture is Extraterritorial Application of Competition Law in European Union, or you can say the European Community or European Commission. Dear learner, the European Union consists of 27 countries having great diversity and have tried to unify the competition law across the European Community besides the pivotal enactment of the United Kingdom known as Competition Act 1998. Today we will be discussing that what is the nature, extent, doctrines, principles, legislative framework, application of the judicial precedent having an impact to have a global precedent or international precedent governing extraterritorial application of competition law. Dear viewer, the extraterritorial application of competition law in European Union is built upon the structure and the edifice of three-pillar approach. The one pillar happens to be the prohibition of cartel. The another pillar happens to be the abuse of dominance. And the third pillar happens to be the control of merger and amalgamations. Having understood the three-pillar approach of the extraterritorial application of competition law in European Union, we will straightway be discussing what is called is the legislative framework of the extraterritorial application in European Union. Dear viewers, Article 85 and 86 of the Treaty of Rome 1985 is the first enactment which provides the ambit and scope of the competition law or the antitrust law, or you can say that the purview of the competition law in Europe. Then UK competition law, which is known as Competition Act 1998, after 13 years of the Treaty of Rome, was promulgated to govern the competitiveness in United Kingdom. The Competition Act 1998 talks about anti-competitive agreements, abuse of dominant market position, and merger and amalgamations, and regulation of combination. Article 85 and 86 of Treaty of Rome 1985 and Competition Act 1998 of UK are being supplanted by an overarching law known as Treaty on the Functioning of European Union, in short known as TIFU, of 2009 and specifically Article 101 to 109 of the Treaty on the Functioning of European Unions encompasses the various colors and shades of extraterritorial application of competition law in European Union. Besides these legislative framework, the extraterritorial application of competition law is deeply embedded into three major doctrines. The first happens to be the implementation doctrine. The second happens to single economic unit doctrine to determine the nature and scope of extraterritorial application of competition law in European Union. However, we also find a categoric mention of the effect doctrine in the European Court of Justice in a catena of decisions on the competition law. As we have the three major laws and we have the three major doctrines taken together that constitute the core of extraterritorial application of competition law, which is being further harnessed and pulled out by a series of decisions, most notably the decision of the European Court of Justice in A. Alstrom-Okoye versus Commission of European Community, popularly known as the Wood Pulp Case 1993, Intel Corporation versus Advanced Macro Devices Incorporation 2004, and Innolux Corporation versus Commission Court of Justice of the European Union 2015. Besides, we have the cases of Microsoft. All these leading cases try to embellish the jurisprudence of extraterritoriality of competition law in the domain of European Union. In this lecture, dear viewers, it is nothing but important for us to get into the details of the European Union competition law regime with the European Commission and core provision, namely Article 81 and 82 of the Treaty of Rome, 1985, for our basic understanding. On the basis of the legislative structure of the Treaty of Rome 1985, we will be in a position to build an antitrust or competition structure of European Union by further perusing these two articles and their two-tier system, whereby the European Commission and the national competition authorities of European Union are supposed to apply and enforce the competition law. More specifically, the abuse of dominance, the economic strength, and prevention of anti-competitive activities in the relevant and the common market of European Union. It can also be understood in the light of the European Court of Justice decision in United Brands versus Commission in 1978 and AKZO versus Commission and 1991 and Hilti versus Commission in 1991 to understand what is called as the doctrine of abuse of dominance under the European competition law. Thus, in short, the legislative framework of the EU, European Union, and the UK's competition law in the light of Competition Act 1998 and Treaty on Functioning of the European Union 2009 provides some of the salient features which says that it forbids anti-competitive agreements. It also condemns the abuse of dominant market position and which has been further pulled out in Chapter 1 and 2 of the Competition Act and enforced by the Competition Market Authority in Europe. Then we will be focusing the emergence of extraterritorial application of competition law under the doctrine of stare decisis as to the what is the nature of the judicial doctrines and the precedent which has been underpinned in the laws and judgment of Article 85 and 86 of Treaty of Rome, Chapter 1st and 2nd of the Competition Act 1998, and Article 101 to Article 9 of the Treaty on Functioning of the European Union 2009, in order to construct the nature of extraterritoriality in European Union and United Kingdom. In the strict sense of the term, the international precedent for extraterritorial application of competition law in European Union laid down precisely in European Court of Justice decision in Intel Corporation and Advanced Micro Devices Incorporation 2005, Innolux Corporation versus Commission Court of Justice of European Union, and Alstrom Ocasio versus Commission of European Communities 1993. Then we will be discussing in detail the ratio and the ruling of the wood pulp case in our understanding of extraterritorial application of competition law in European Union. Then we will be referring to Innolux case and will try to pull out some of the finest principles of law and the divergence of legal basis between the European Union and the United States and its consequent implications and ripple effect for global supply chains and competition rules. As we know that in Innolux case, the Court of Justice of European Union confirms 288 million pound of fine in a cartel on the market of LCD panel. Thus, by all kind of discussions, we will be comfortably be in a position to construct the nature of European communities competition law and some of the finest dimensions of extraterritoriality underpinned in these laws and judgment. And in conclusion, we will be referring to, dear learner and viewer, that the European Union has concluded a series of bilateral cooperation agreement with a number of countries, and competition law happens to be a driving force behind Antitrust Corporation in a multinational antitrust fora, and it has very brilliantly filled up the philosophical gulf between how certain conduct in the unilateral conduct and comes in conflict in the extraterritorial application of competition law, and how all the three doctrines which happens to be in vogue are to be implemented strategically in the domain of the competition law. With this introduction, dear learner and viewers, we will again try to preface that what is actually the extraterritorial application of competition law in European Union. European Union is a key global player in the market and assertively applied competition law and policy to foreign entities, having adverse impact on domestic jurisdictions and business. The EU competition law rests on three pillars: prohibition of cartel, abuse of dominant position, and merger control. The EU embraces extraterritoriality out of necessity and not as a convenience, but emerge as a multipolar governance of transnational anti competitive conduct in global competition law and policy. The competition rule, which are set forth in the European Community in Article 85 and 86 of the Treaty of Rome 1985 and the UK's Competition Act 1998, are all designed to stop anti-competitive behavior, which may tantamount to anti-competitive agreement or abuse of dominant market and regulation of cartel. This is being supplemented by Article 101 and 109 of the Treaty on the Functioning of European Union 2009 in contemporary context in an overarching manner. Thus, the extraterritorial application of European Union competition law has been a subject of debate and involves the implementation of doctrines and single economic unit doctrine to determine the jurisdiction. The European Court of Justice judgments are ambivalent in affirming effect doctrine of United States antitrust law, but remains a universally recognized concept under the European Community competition law. The extraterritorial application of competition law in European Union laid down in European Court of Justice decision in A. Alstrom Osaka HO versus Commission of European Communities, popularly known as the Wood and Wood Pulp case of 1993. Secondly, the Intel Corporation versus Advanced Micro Devices Incorporation 2004 and Innolux Corporation versus Commission of Court of Justice of European Union 2015, and have meticulously shaped the application of European competition rules by setting an international precedent. In this respect, dear viewers, a study of Treaty of Rome 1985 becomes sine qua non. And in this context, the European Union competition law regime, with European Commission at the apex of its enforcement structure, has steadily evolved to become one of the most mature regimes in the world. Its core provisions, namely Article 81 and Article 82 of the Treaty of Rome 1985, do not, however, explicitly indicate whether they find extraterritorial application or not. Therefore, it becomes imperative to have a perusal of these provisions in detail. Article 81, subclause 1 of Treaty of Rome prohibits all agreement between undertakings, decisions by association of undertaking, and concerted practices which may affect trade between member states and their object or effect in the prevention, restriction, and distortion of competition. Article 82 of EC European Community Treaty on Rome Treaty prohibits the abuse of dominance and the notion of substantial part of the common market and a single knit European market. The competition rule of European Community, therefore, are set out in Article 85 and 86 of Treaty of Rome 1985, thus places three restrictions. The first forbids and as incompatible with the common market agreement that may affect trade between member states and restrict competition. The second is the abuse of the second is the abuse of dominant position, meaning thereby Article 85 and 86 are the starting point of an intricate competition regulatory system and prevents not only the naked horizontal cartels and abusive behavior by dominant undertaking, but it also forbids distribution agreement, franchisee agreement, the licensing exercise of exercise of intellectual property rights and joint ventures and other forms of collaboration between the undertakings. Out of the study of Article 85 and 86 of Treaty of Rome of 1985, we can construct an edifice of the antitrust structure of European Union. And this legislative framework, in a sense, in European Union and UK's competition law, based on two-tier system. And by saying the two-tier system here, we mean European Commission at the one hand and national competition authorities on the other hand. Both have parallel competence to apply Article 81 and 82 of the Europe Treaty of Rome. Seen in this perspective, dear learner, the anti-competitive agreement or practice contributes to improving the production or distribution of the goods, to promote technical economic progress while allowing consumers a fair share of benefit, and which does not impose on the undertaking concerned restrictions which are not indispensable to the attainment of the objectives. In a way, it affords such undertaking the possibility of eliminating competition in respect of substantial part of the products in question. Seems to be the impact of Article 81, whereas Article 81 subclause 1 of the Treaty of Rome 1985, which prohibits agreement between undertakings, decisions by association of undertaking, and the concerned practices between undertakings, decisions by association of undertaking, and concerted practices which restrict or distort competition or which may affect trade between member states. Thus, a concerted practice has been described as a form of coordination between undertaking, which, without having reached the stage where an agreement, properly so called, has been concluded, knowingly substitute practical cooperation between them for risk of competition. In a similar vein, and the natural corollary, Article 81, subclause 3 prohibits inapplicable on the fulfillment of narrow category of cumulative criteria and cartels. Thus, the reading of 81 subclause 3 and 82 leads that it prohibits the abuse by one or more undertaking of a dominant position within the common market or in a substantial part of it insofar as it may affect trade between all the member states within the European community. Then it is nothing but natural to look at the legislative purview of the Article 81 and 82 of the Treaty of Rome 1985 in the context or a specific context of abuse of dominance in the European community law. The abuse of dominance under the European community law can be understood in relation to a position of economic strength enjoyed by an undertaking which enable it to prevent effective competition being maintained on the relevant market. An abuse is characterized by the exploitation of customer or the exclusion of competitors. In particular, the abuse of dominance contains types of conduct are deemed to be an abuse of the dominant undertaking, which can be understood: number one, the direct and indirect imposition of unfair purchase or selling prices or other unfair trading conditions, the limitation of production, market, or technical development to the prejudice of the customers and consumers, the application of dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage, and making the conclusion of the contract subject to acceptance by the other parties of the supplementary obligation, which by their nature or according to commercial usage have no connections with the subject of such contract. Thus, with the discussion of Article 81 and 82 and the specific connotation and the context of abuse of dominance, we can proceed to two, three cases on the point to bring home the conclusion which has been handed down by the European Court of Justice decision in United Brands versus Commission in the year of 1978, AKZO versus Commission in 1991, and Hilti versus Commission 1991. These cases and their ruling taken together leads to the ratio and ruling that by giving it the power to behave to an appreciable extent independently of its competitor, customer, and ultimately of its consumer, is considered abuse of dominance under European Community's competition law. And a presumption of dominance arises where an undertaking has a market share of 50%. An additional factor, no doubt, should also be taken into consideration in order to establish dominance, especially where the undertaking holds a market share of more than 50%. Thus, in the light of these three decisions, we can conclude that such factor as we just discussed about also include the ownership of intellectual property rights and the superior technology in establishing the symbiotic relationship of competition law and innovation. Now, dear learner, we will be switching over to the legislative framework of the competition law in a specific reference to the United Kingdom. The legislative framework of the competition law in EU, in European Union and the UK can not be understood in isolation unless we try to synergize the Competition Act 1998 of UK and Treaty on the Functioning of the European Union 2009 taken together and read together. Thus, the UK Competition Law or Competition Act 1998, which is designed to stop anti-competitive behavior, leads to certain broad generalizations and salient features, which happens to be number one, anti-competitive agreement, abuse of dominant market position, and all these concepts are permeated under Chapter 1st and 2nd of the Competition Act 1998, and it is administratively administered and executed by the Competition Market Authority. Thus, UK competition law primarily designed to protect underdog consumers or business from anti-competitive agreements or abuse of dominant market position. The domestic competition law of the United Kingdom imposes significant penalties for non-compliance for trading international business under Article 101 and 102 of the Treaty on the Functioning of the European Union 2009. This can be buttressed by the example that if any company faces a cartel investigation, it could be subject to the CMA, which means Competition Market Authority, and Article 101 initiate investigation of the alleged anti-competitive conduct which took place in United Kingdom, which takes place in United Kingdom and European Union and other member states. In this context, we can see that the European competition law derives the life, breath, and sustenance from Article 101 to 109 of the Treaty on the Functioning of the European Union 2009, as well as a series of regulations and directives issued time to time by the European Union, notices, circulars, and promulgations. A holistic understanding of all these regulations and directives lead to certain broad elements which are primarily concerned with cartels, control of collusion, and other anti-competitive practices which are found in the European Union regulations and directives. Thus, we see that Article 101 of the TEFU 2009 prohibits business agreement or arrangements which prevents, restricts, or distort competition within the internal market and affect trade between all member states, meaning thereby the 27 member states in European Union and other parts of the globe. Whereas Article 102 of the TEFU 2009 prohibits as compatible with the internal market any abuse of any undertaking which can be colored by a brush known as the dominant position or abuse of dominance. With this, dear learner, what we discussed is the panoply of the European competition law in the context of three major legislative exercises which have its repercussions on extraterritoriality of the competition law and the three-pillared approach of the prohibition of cartel, abuse of dominance, and control of the merger, deeply embedded under Article 85 and 86 of the Treaty of Rome 1985, United Kingdom's Competition Act 1998, and Article 101 to 109 of the Treaty on the Functioning of the European Union, and its application and incorporation and indoctrination under the implementation doctrine and single economic doctrine and the effect doctrine in the light of the decisions of the European Court of Justice in Wood Pulp case of 1993, Intel Corporation case of 2004, Innolux case in 2015, to have a broad understanding of extraterritorial application of competition law in European Union. I hope that at this stage we will not be able to have some kind of a sweeping conclusion unless we peruse meticulously all the rulings and ratio of these cases and the nature, application, and enforcement of all the doctrines of the European Union, which will be taken in two subsequent lectures. Till then, thank you very much. Have a happy learning.